Right.
Good morning. 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. Our court is in session. There will be no eating, sleeping, talking, gum chewing, and reading materials.
Thank you. This is case number 22190602. This is Jordan Irby versus Denise, Dennis Coleman. The matter is before the court on the issuance of a subpoena. Today is date time set for a hearing in that regard. Do I have Jordan Irby on this Zoom? Say something if you're here.
Yes, I'm here.
All right, thank you, Mr. Irby. Good morning to you. Do I have Dennis Ptolemy? Dennis Ptolemy? All right. Mr. Irby, is there yet an outstanding balance on the judgment?
I'm sorry, can you repeat that, sir?
Is there yet an outstanding balance on the judgment, sir?
Yes.
All right. All right. It appears that the defendant has not appeared regarding this subpoena in this matter, and for that reason, the court will issue a show cause in this matter, and I will set the show cause hearing date in this matter for. It's going to be April the 29th. April 29th. So what you'll need to do, sir, April 29th at 9:30. What you'll need to do is you'll need to get a show cause form filled out and submit it to me right away, so that I can get that show cause. I've already given you the date for it. It's going to be 4/29/25 at 9:30 a.m. Get that to me. I'll get it signed, and then you'll need to get to serve it on the defendant. If he doesn't appear for that date, the court will issue a bench.
Okay.
All right. All right. I wish you well, sir. Good day to you.
You too, sir.
All right. The court now calls case number 24162086. This is Rivercrest Arm Owner LLC versus Alice Faye Kennebrew. The matter is before the court. Set on for a hearing on a motion for summary disposition. Your appearance for Rivercrest, please.
Good morning, Your Honor. For the record, Jason Katz for the plaintiff.
All right, thank you. Your P number on the record, please, Mr. Katz.
P62923.
All right, thank you, counsel. Good morning to you. I'm looking now for Alice Faye Kennebrew. If you're on the Zoom, please say something at this time.
Good morning, Your Honor.
All right, good morning to you, Ms. Kennebrew. All right, Mr. Katz, you ready to proceed with regard to your motion, sir?
Yes, Your Honor.
And Ms. Kennebrew, I'm looking and I do not see where you filed a written response to the motion. You did not file a written response to this motion. Is that correct, ma'am?
No, I don't have an attorney, so I really didn't know what to do.
All right, thank you, ma'am. Thank you. Counsel, you may proceed on your motion.
Thank you, Your Honor. This is a lawsuit to collect some rent from the default on an apartment lease. Ms. Kennebrew had it's spelled out in her motion, but she had a lease that she broke the lease early. The lease provision provided for 2 months rent if a tenant did that. And so what we're seeking, Your Honor, is 2 months minus her security deposit. And then my client was able to find a tenant, I think it was approximately 6 weeks after. So they're only seeking the net amount that they would have received up until the time that they found a new tenant, which amount is, and again, this is spelled out in the motion. The amount was $1,019.66. In our motion, we're also seeking costs and the statutory attorney fee. And Ms. Kennebrew, the only defense she stated in her answer was that there was a previous case that was dismissed, and that is true. It was dismissed without prejudice, I believe, because my client was able to serve her. It was another attorney handling that case, but nothing's been dismissed with prejudice. We've explained that in our motion. We sent a letter to Ms. Kennebrew trying to work this out. We didn't hear back.
I've never received a letter. I've never received a letter.
You know, you can't start talking while somebody else is talking, so you already know that, that's all. Just hold on a second, ma'am. Just hold on. All right, you may continue, sir.
Okay, the letter I don't think is really impacts the motion, but it's all spelled out in the motion, Your Honor. Ms. Kennebrew has not filed an answer. And we'd ask that the court grant the motion and enter a judgment in the amount stated in our proposed order, which is, I'm sorry, it is $1,215.99.
All right, and Council, let me just ask you, in looking at the lease document, the monthly rent in that document was some $920. To the best of your knowledge, is that correct, Council?
Yes, Your Honor.
So if we were just going with a full 2 months, that would be like 1,880 before any other expenses, correct?
I believe it's it would have been 1,840 if it was the full 2 months, but she's been credited with the again, the security deposit, which I believe was $399, and then $531.34, which was rent they were able to get from a subsequent tenant.
All right, and I see that the security deposit is $299, at least in the written document. And you would go along with what the written document says, correct?
Yes, but I believe, let me just double check. I think she paid more than $299. So we wanted to give her credit, obviously, for the full amount she paid. Let me just confirm that. Yeah, let's see here. I just want to make sure I get this right.
I see on your itemization document, it indicates the $299.
You're right, Your Honor. It was $299, not $399. My apologies.
All right, thank you. Thank you, Counsel. All right, Ms. Kennebrew, the nature of the motion, is that you left early, and that within the context of the lease agreement says that there is possible penalties that attach to that if you leave early, and that is that you're responsible for those months. Go ahead and talk to me, ma'am. Tell me what your response to this motion is, please. Yeah, you're still on mute, ma'am. So go ahead and take yourself off mute, or hit *6. That'll get you off mute. There you go.
Okay. Your Honor, I did leave the apartment early due to the fact that I was ill. And I spoke to the management there. My son, I had to live with family members, and I couldn't stay any longer. The people that moved into the unit, they moved in a unit within a week after I moved. The unit was left spotless. There was nothing for anyone to do. But I moved because I couldn't stay there by myself. I was sick.
All right, then. All right. Thank you, ma'am. Mr. Katz, anything further on this motion?
I have nothing further to add, Your Honor.
All right, I've listened to the motion for summary disposition regarding this matter, which sounds in MCR 2.116C9 and C10. They claim that there is no genuine issue of material fact, and that relates to where the parties agree. That is that the lease was broken, and Ms. Kennebrew has indicated to the court that she broke the lease and that it was due to physical ailments that she was suffering. What she would have had to do at that stage is she would have had to receive a written release or point to a provision within the lease itself that allows for such an exit from the property. If she's going to leave early, she would have had to get a written release from the lease for conditions that she would later raise in this matter. Without that, she does not have a defense to provisions contained within the lease agreement. Also, she's raised the issue that someone moved into the property subsequent to her taking the property. The plaintiff says that it was 6 weeks out. She said it was a week after she left. It would be necessary to confront the motion in this matter with an affidavit establishing the same. Without that, that certainly would not rebut the issues that are raised by the motion in this matter. My determination is that the plaintiff has established the claims asserted as it relates to the motion. There is no genuine issue of material fact. For that reason, the motion will be granted. No factual scenario really could support a different outcome, given the fact that the lease was in fact broken and there was no mutual agreement allowing the same to occur. The motion will be granted accordingly, and judgment will enter on the granting of the motion, and the total judgment amount is $1,215.99. That includes cost and the statutory attorney fee. That is my order. Both parties will receive a copy of my order in the mail in the next few days. Good day to both sides.
Thank you. Have a nice day. Your Honor.
Thank you, Your Honor.
The court now calls case 24-166-896. This is Citibank versus Rowena Golson. The matter is before the court set for its first hearing. This is a status conference. The claim in this matter alleges damages in the amount of $5,140.02. Your appearance for Citibank, please.
Good morning, Your Honor. Jay Baig, B-A-I-G, P36820, appearing on behalf of plaintiff.
All right, thank you, Mr. Baig. Good morning to you, sir. I'm looking for Ms. Rowena Golson. If you're on the Zoom, please say something at this time. Ms. Golson? All right, counsel.
Can you hear me?
I can barely hear you. I do see you there now, ma'am. You might need to turn your volume up there. All right, but good morning to you, Ms. Golson. Counsel, have the parties spoke, update me on the status of where things are at this point, sir?
Well, we haven't spoken because Ms. Coleman apparently is represented by a consumer legal group. In part, they're responsible to respond to legal proceedings against Ms. Golson, represent her in legal proceedings and engage in other competent counsel. So, to my knowledge, you haven't filed an appearance. We could do one of two things, Your Honor. Either adjourn this pretrial for maybe 30 days, or status conference for maybe 30 days, so that Ms. Golson can reach out to them and see why they haven't filed the appearance, or we could just do a scheduling order with some discovery.
How did you find out that there was potentially counsel in this matter, sir?
Because they filed a cease and desist communication to counsel on behalf of Ms. Golson, and then we're in possession of the limited power of attorney that they supply to plaintiff's counsel.
All right, thank you, counsel. Ms. Golson, there's an attorney or somebody or agency out there representing you. Is that true? Is that true, ma'am, Ms. Golson, that some agency or someone is representing you?
Can you hear me?
Yes. All right.
Yes.
So I'm going to adjourn this so that they will need to file some response before the next court date. So I'm going to give it a new court date. That date's going to be the 28th of April, 4/28/25 at 9:45. They'll need to have some response in at that time so the court can know what position they're taking on your behalf. So you'll get a notice with that new date. Make sure that you advise and let them know that your next date is April 28th, 2025 at 9:45 a.m. I'll go ahead and set the matter as an adjourned status conference.
Okay.
All right, good day to both sides.
Thank you, Your Honor.
Bye.
All right, this is case number 24-168-521. This is Troy Gap LLC versus LaShawn strike that. LaShawn Kendrick, I'm looking at, and I'm also looking at Pamela Kendrick. Today is the date and time set for a pretrial hearing on this matter. I previously issued a scheduling order. All right, your appearance for Troy Capital, please. Troy Capital. I believe that Mr. Rusin is representing Troy Capital. Mr. Rusin? All right, do I have any other parties regarding this matter? Do I have Hendricks?
Yes,
Right,
here.
all right, looks like Pamela Kendricks, correct?
Yes.
All right, do I have LaShawn Kendricks? Say something if you're here.
I'm here.
All right, thank you. I'll come right back to your matter as I believe the attorney is in another courtroom. All right, so just stand by. I'll come back to your matter shortly.
Okay.
All right, this is case number 24171353. This is LBMB Funding LLC versus Cherie Morrow. The matter is before the court, set on for a status conference. I believe I have it set for. All right, do I have LBMB Funding? Looks like Mr. Rusin is representing LBMB Funding as well. Do I have Cherie Morrow? Or if you're on the Zoom, say something. All right, good morning to you, ma'am. I'll be coming back to your matter shortly. We're gonna try to get the attorney in here. He's in another courtroom. All right, the court case number 24240915. This is Ramona Berry versus Auto Plant Supercenter. The matter is before the court, set on for a hearing on a subpoena. Your appearance for, do I have Ramona Berry? Do I have Auto Plant Supercenter? All right, I do have a notation indicating that on the 14th of February 2025, that a check was made from MTN Auto Center to Larry Berry and Ramona Berry for the amount of $2,562.83.
That is correct,
All right, who's talking? All right,
Ramona.
I didn't answer when I called for you, so you got paid already?
Yes.
All right.
We didn't get any we didn't receive any notification, so and by this here saying subpoena, I made sure I was online today.
All right, good enough. You're the one requested a subpoena and I signed it for you and set it for today's date. So you had to know about this because you're the one that asked for it.
I knew about this, but the check came after this was done.
Oh, that check is dated back in February, so you just got it done?
Yes, we've had about 2 weeks now.
Why, you cashed it?
Yes.
All right, so you all set then, right?
Yes.
All right, we'll close this matter out, finding that the judgment has been satisfied. I wish the two of you well. Good day to you now.
Thank you. I'm getting ready to run.
The court now calls case number 24165169. This is BCG Equities Limited, Stricta LLC versus Latira Baker. The matter is before the court, set on for a status conference. I have it set. I do have the filing of a motion for summary of disposition that was submitted to the court on the 26th of March of 2025. Your appearance for BCG, please.
Attorney Ashley Nelson appears on behalf of the plaintiff P84103.
Thank you, Ms. Nelson. Good morning to you, ma'am. I'm looking for Latira Baker. If you're on the Zoom, please say something at this time.
Good morning.
All right, I see Latira Rudolph. So am I going with Rudolph or Baker?
Rudolph.
All right, thank you, Ms. Rudolph, and good morning to you, ma'am. All right, so this is the first hearing regarding this matter. Plaintiff did file a motion for summary disposition. Have the parties talked about this at all?
Yes, Your Honor, the parties were in a breakout room this morning. We have reached terms for resolution. We're going to put those in a conditional dismissal, and Ms. Rudolph has given me permission to sign that agreement on her behalf.
Is that correct, Ms. Rudolph?
Yes.
All right, why don't you go forward and set forth those terms on the record for me at this time?
Yes, Your Honor. So Ms. Rudolph is going to pay the sum of $2,339.58 at a rate of $50 per month. Her first payment will be due April 15th, and then the 15th of each month thereafter until she's paid in full. Should there be a default on the agreement, the plaintiff could file an affidavit of noncompliance and a petition to reopen the case and enter judgment in the balance paid for in the complaint minus any sums Ms. Rudolph had paid prior to default.
All right, that sounds like the agreement you entered into, Ms. Rudolph?
Yes, Your Honor.
All right, I will sign then a document submitted to the court that comports with those terms. I've documented the terms, and I look forward to seeing that agreement submitted to me. I wish both sides well. Good day to you.
Great,
You
thank you,
too.
Your Honor.
And this is a recall regarding the suffix 8521. This is Troy Capital LLC versus Pamela Kendrick and Lucerne Kendrick. Both of the defendants have indicated their presence here. Your appearance for the plaintiff regarding this matter, sir.
Judge, may I please court? My name is Attorney Richard Bruson. My bar number 35222. I'm the attorney for the plaintiff. I'm also the petitioner for plaintiff's motion for judgment.
All right, thank you, counsel. Mr. Rosen, as an officer of the court, update me on where things are. I did see that there was a motion to set aside a default. I ruled on that matter on the 18th of February, indicating that I did not see where there was a showing of meritorious defense. That was regarding Sharon Kendrick. I believe that there is a matter pending before the court regarding Pamela Kendrick. But go ahead, as an officer of the court, and update me if you will, sir.
Judge, when I looked at defendant Pamela Kendrick's answer to the complaint, it appears that she's admitted the balance due. Actually, I should say she admitted all the allegations of the plaintiff's complaint. Therefore, I filed this motion for judgment based on the deficiency of a car note between the parties. Those supporting exhibits have been attached to my motion. You should have them on your bench, Judge. I shall also tell you that pursuant to MCR 2.116G1, that court rule requires, it says, a respondent must file a written response to a motion for summary judgment at least 7 days before the hearing date. I am not in receipt of an answer. I would ask that you grant motion for judgment in the amount of the complaint plus statutory costs and interest. On that, I rest.
All right. So this sounds like this was a deficiency balance regarding a vehicle that was repossessed. Counsel. So, ma'am, it looks like Mr. Lucerne Kendrick is in default. The motion is filed as to both. I have not received any written response. Tell me, ma'am, let's deal with Miss Pamela Kendrick. What is your response regarding this matter, ma'am?
My response is, I did inquire this car. It wasn't repossessed. I actually gave the car back because they had informed me that I still owed $10,000 on a car that I have already spent over $35,000 into the car. So I was wondering, why am I still owing $10,000 and you've gotten well over almost $40,000?
All right, so it looks like you entered into this agreement to purchase the vehicle back in 2012. It looks like there was a contract in the nature of $36,000 or so. And then it looks like there was a default on the vehicle. It was repossessed or turned in, essentially the same thing. And then it was sold and there was a deficiency balance. So it's that deficiency balance that seems to be the issue here.
Yes.
So.
I see, Judge, if, to be helpful, I see attached as an exhibit, I'm looking at a October 5, 2021 document from the original car note lender that has an explanation of calculation of the deficiency. It's all laid out in a bullet point fashion, goes right down to the balance of the complaint, which was filed for $32.14. I have also attached all the necessary documents under the Uniform Commercial Code that shows that defendant was notified of the repossession, was told what to do in case you wanted to redeem the car. After the car was sold, there was another notice of the sale with, you know, all the requirements met under the Uniform Code. So therefore, Judge, based on the record, I ask for judgment.
All right. Thank you, counsel. All right, Mr. Kendrick, I know that there was a default entered against you regarding this matter. What did you have to say regarding this motion, sir?
Are you speaking to Pamela or LaShawn?
LaShawn.
I'm a miss.
LaShawn. Oh, I'm sorry. The name throws me off a little bit. All right. So tell me anything you wanted to say this time.
No.
We did go down to 36th District Court, and she did fill out paperwork.
All right. Thank you. All right. I've listened to the motion for summary disposition regarding this matter, where it alleges that there is not a factual defense to the claim that any pleadings offered are deficient. This seems to be a rather straightforward matter, where there was a contractual agreement for the purchase of a vehicle. There was a default thereon. As a result of that default, the vehicle was repossessed or turned in. It was sold, and there was a deficiency balance. That deficiency balance is what the plaintiff had sued upon. I don't see a defense to that, and therein lies. I don't see a defense to that, and I don't see. And when I talk about there not being an answer to the motion, I'm not talking about an answer to the complaint. The reason that we're still here is because there was an answer to the complaint. This particular type of motion, there's a requirement for an answer to the motion. Although I went forward to make inquiry as to whether or not it was an oral answer. And taking everything into consideration, I still do not see where there's a genuine issue of material fact. The plaintiff is entitled to judgment on this matter, where the vehicle was sold, but there was a deficiency balance after the vehicle that was sold on the contract. And for that reason, the court will grant the motion for summary disposition and allow judgment to enter on the same. That is so ordered. All right, and the parties will receive a copy of that order once the court has signed the same. Good day.
Thank you, Judge.
Mr. Rusin, you have another matter in front of me.
Yes, I do, and I have a consent judgment to put on the record once you call the case.
All right, this is case number 24171353. Again, 24171353. That's LVMB Funding LLC versus Sharif Morrow. The matter is before the court, set on for a status conference hearing. Your appearance for the plaintiff counsel.
Judge, may I please report for the plaintiff? I'm attorney Richard Rusin. I'm the attorney of record, and my bar number 35222.
Thank you, Mr. Rosen. Good morning again. Ms. Morrow, I know she answered earlier. Good morning to you, Ms. Morrow. Again.
Good morning.
All right, thank you. And Mr. Rosen, you may proceed at this time, sir. You said you had some information on this matter.
Thank you, Judge. May it please court, Richard Rusin on the record. Judge, this is a case where the parties have entered into a consent judgment while the case is in the breakout room and recess. The parties will agree to enter a consent judgment and the amount of the complaint filed for $1,162.82. That's 1162.82. Judge, I explained to Ms. Morrow what are called taxable costs in Michigan law. Consist of a $55 summons filing fee, a $69.19 summons service fee, total cost of $124.19. That's 124.19. I explained to Ms. Moore about what the state of Michigan calls a statutory attorney fee, which amounts to $75 concurrent with the entry of this judgment. Total consent judgment will enter, Your Honor, in the amount of $1,362.01. That's 1362.01. More importantly, the parties have further agreed that concurrent with the entry of this consent judgment, that Ms. Morrow will pay an installment payment of $50 monthly beginning May 1, 2025. And before I rest, as I explained to Ms. Morrow in the breakout room, I asked Ms. Morrow's permission on the record to sign her name to the proposed consent judgment so that I can file that order with with the clerk's office, Your Honor, before 9 a.m. tomorrow. With that, I rest.
All right, I've gone over and documented the terms as set forth on Ms. Morrow. Is this the agreement that you've entered into at this time, ma'am?
Yes, Your Honor. Yes.
Anything else you wanted to bring to my attention at all, ma'am?
No, there's nothing else. Thank you.
Thank you. The judgment will enter by consent upon presentment to the court. And I've documented the terms, of course, and I'll sign it as long as it's the terms that are set forth on the record. All right. I wish both sides and good day to you.
Thank you, you too.
Thank you, Judge. On that, I rest. Have a great day. Ms. Morrow, thank you very much.
Thank you. Bye-bye.
Why do I have Mark Garza disappeared?